Are you doing well?
Yep. How are you?
Good.
Good. I was hoping you would come in here and say you wasn't going to make that move.
Why would you want me to do that?
Selfish reasons, of course. Said, oh, he ain't going. First thing he said when he said, I'll go.
It's too good of a, really, I know we still on the thing, but it's too good off.
Huh?
I am, I'm grateful. I'm
You
really-
talking to me or you on the phone?
I'm talking to you, I'm grateful.
Yeah, I know you are. I know you are.
But the more that we talk about, the more we get into the details of, the better it is.
Well, it was nice for you to come in this week. Did you hear me? Said it was nice for you to come. It was nice for you to come in this week.
Yeah.
I didn't know, you know. That's Tifa, she told me.
Mm-hmm. You said, Joe?
I ain't trying to run out of it.
Yeah. That's okay. I told you we'll get the handcuffs. We'll keep you here.
Yeah, it's gonna be weird. Here comes somebody.
Just one moment. All right, thank you. We're back on the record on the suffix 0070. The parties have been in a breakout room. Now, Madam Council, go ahead and update you on where things are at this group. Ms. Davis, if you heard me, go ahead and update me on where things are, Madam Council.
Yes, Your Honor, so we had a chance to speak. Ms. Westbury's claim is a little different than I originally realized. So I am going to go back and speak with my client. If you could give us a scheduling order just to give us some time to do that, but I may be able to resolve this after speaking with my client.
Right. So Ms. Westbury, I'm going to go ahead and set it up as I was mindful to do previously, but you guys have talked and that may be the groundwork for some ways that this might be resolved. Short of that, you can come back to court on the 24th of July, and it's going to be at 10 o'clock a.m. 7/24, 10 o'clock a.m.
I'm sorry, you said 10 o'clock?
Yes, 7/24, 10 o'clock a.m. And you'll get that in the mail from me. It will be inside of the scheduling book. It'll have a part that says notice period. It will have that date of 7/24/25 at 10 o'clock a.m. And unfortunately, there will be another judge, though. But I think you all kind of picked up on that already. So,
Congratulations.
but thank you. It's a great opportunity, and I love doing what I'm doing here. So, it's got to be a great opportunity. And I don't even know how to do that at 32 and a half years.
That's okay. You'll figure it out.
All right. Good day to you. Good day to you,
All right.
Kelsey.
Thank you.
Thank you, Your Honor.
They're just a small company. So what I indicated to Ms. Servey this morning is if the case is that they must garnish his wages, they're just not going to contract with him anymore, Your Honor. So they won't be working with Mr. Johnson no further. But he's not an employee of the company.
All right. Well, that may help things going forward, I guess, in retrospect. Counsel, this survey, did you have a calculation as to what should have been paid out regarding any disclosures or anything?
We don't have a dollar figure as to how much should have been withheld from the date of service of the writ, but we do have that the writ's been served since November 12th of 2024. So it would be the biweekly or whatever the garnishment per pay period is since that time, and costs in no less than $100. The $100 is per the court rule 3.101 S3. I would need to get back with the court and garnishee about the exact amount that should have been garnished, as we have no concept.
Mr. Santo?
Yes, Your Honor. The only thing I would say to that is Mr. Johnson, all of his previous payments have already been paid out. I don't know how my client could essentially retroactively, it will essentially cost them payments if they're not going to be contracting with them anymore. It's just going to cost them a bunch of money. I'm not sure how this would work.
Yeah, but that's unfortunately, that's their problem, is that the way that this works is if they should have, under the law, withheld funds and didn't, and that's on them. They could certainly go after Mr. Johnson to recoup what they erroneously paid out. That's not credit acceptance. Have you guys talked some type
Your
of
Honor,
resolution?
I'm sorry.
Talk about this. You reach some type of resolution. Otherwise, what the first thing would be a disclosure of how much money was sent to Mr. Williams over that horizon, November to the present time, and then the calculus would be based upon those numbers. However, you could, as parties often do, you could agree to something that shuts the door on this for now, particularly where there's indication that Mr. Johnson will not be used as a contract. Where this goes on. So my question was whether the two of you talked about what a resolution might look like before we go to that next step.
We have not yet, Judge.
Well, let me, Madam Counsel, do you have any thought while you think of the disclosure? Do you have any thought about what the numbers may look like in this matter?
Again, we haven't received any payments, so I'm not even sure what 25% would be since that time. It would just be what should have been garnished is what we would be seeking. So without knowing what his typical pay is, I can't even speculate.
All right, so I'm gonna send you to a breakout room, and then you come back in and see if you can find any traction. So if you can't, just come back in. I'll get right back to your matter. And what will happen is that I think, Mr. Manzura, I don't see where there's any other option than to get a number as to what was paid out to you, because that becomes a part of the calculus for determining what should be withheld. And of course, going back and collecting money from Mr. Johnson, that onus would be on the company because they didn't respond to the writ. So let me put you guys a breakout room and just talk about it, see if you can find some room. If not, just come back and I'll figure it out. I'll see you on the other side. This is case number 24-166-139. This is JP Morgan Chase versus Allison Henderson. The matter is before the court, set on for a hearing on a motion for summary disposition. The case was dismissed in error on the previous case, and apparently there was some discussions that were had that the parties were trying to reach a resolution. Your appearance for JP Morgan Chase, please. Counsel for JP Morgan. All right, do I have Allison Hendricks on the Zoom?
I'm here, yes. Good morning.
All right. Is it Hendrickson? Or is it?
Oh,
is it Hendricks?
Hendrickson.
Okay,
Hendrickson, yeah.
all right, the file has Hendricks, so I'll make that adjustment. So you spoke with the other side and you got this resolved or something? What happened here?
No, I'm working with AmeriCorps, the debt consolidation program. And this is the last step we have to settle. I'm just waiting to build up the funds so that AmeriCorps can negotiate on my behalf. I'm just back from maternity leave a few months ago, so I'm earning again. So it's just taking a little time, but I've been building up some momentum and we're getting there. It's just, I'm not all the way there yet.
All right, so, and so the company that you're working with, that is,
Case goes forward, that'd be filing a motion for summary disposition in this matter.
all right. So when the parties are not able or not willing to discuss possible resolutions, the next step is for the court to set a scheduling order on the case. And so, Ms. Westbrook, my understanding is that you did not want to talk about this. So I'm going to go ahead and set this up for a scheduling hearing. Do you have something you wanted to say?
No, I didn't know. I didn't know that I had to speak with her about this case. So that's why I say I didn't know if we needed to speak or not. I didn't know if she wanted to speak or not.
The first step in these matters is oftentimes the parties trying to find out exactly where they are, whether or not they can reach an agreement. And if they can't, they can. If they can, sometimes people find a way to resolve it. And then if they can't reach an agreement, then the first thing that I do is set it up on the trial discovery process with a 60-day discovery period where interrogatories, requests to admit, documents being set up, what are required to be answered by either side. And then at the end of that process, oftentimes parties will, cases are crystallized. And then beyond that date, the court will look at setting up hearing on motions and then ultimately setting a trial date if that is necessary. So the first step is always in a process called discovery. It also allows the parties to file motions for special hearings that they may want the court to conduct. And so that's the process that I would step to now, given that the parties have not been able to reach a resolution. Anything you wanted to say at this time?
Yeah, I agree. After we spoke, yeah.
All right, very well. So the next action date in this matter is going to, what we have, the 24th or the 25th?
No, you're talking about
Pre-trial.
pre-trial, you want 60 days?
Yes.
Oh, okay. Yeah.
Oh, yeah.
July the 20, you can do the 24th if you want.
Okay, July 24th is going to be the next action date, and that's going to be at 9:30. You will get that date in the mail. In the scheduling order, that date will be a part of the scheduling order. So 7, 24, 25, 9:30 a.m. And unfortunately, Mr. Kuiper, as you've seen me for many, many years, I won't be here.
Oh, well, sad to see you go, Judge. I do have one other matter with you today, though.
We'll address that. I took on an assignment with the Supreme Court, and I'm going to be leaving here after 32. It would have been 33 years in October, so after 32 years.
Wow.
So Ms. Parrish, you won't see me when you come back, but we'll have somebody good and what have you that you can talk to when you come back.
Okay.
All the best.
Okay.
Mr. Peck, what's your name, sir?
The other matter is Citibank and Monica Knight.
Thank you. This is case number 24-175825. This is Citibank versus Monica Knight. The matter is before the court, set on for a hearing regarding the status conference. I believe this is the first hearing. I am in receipt of the answer. Looks like the first hearing anyway. Or your appearance, counsel.
Good morning, Your Honor. Matthew Kuipers on behalf of plaintiff P 71348.
Thank you, Mr. Kuipers. For defendant, your appearance, please. For defendant, Monica Knight, do I have Monica Knight or do I have counsel? Looks like I saw an attorney on this matter. Counsel, you're in
There's
contention.
actually been a resolution. Consent judgment was signed by the defendant already. We just need additional time to get that filed with the court.
All right, thank you, Mr. Kuipers, for that update. I am going to note to the file that the parties have resolved the matter and that the court is waiting. All right, thank you, counsel. Good day.
Thank you, Judge.
Never been late. We're just getting to a certain amount so that they can negotiate with Chase. It's the last one that's left. I've already paid off the others. So.
All right, I don't know why they're not here. That is the parties from Chase, but I kind of remember this based upon the last time that he was here. So what I'm going to do, Ms. Henderson, I'm going to go ahead and adjourn it over to allow the process a little bit more time. And so I'll bring it back about 30 days from now to see what the parties are. That makes sense to you?
I'm sorry, you said we'll talk about it again in 30 days. I'll turn it.
Yeah, that's what I was saying. That's, I thought is to put it over for 30 days. The other side is not here at this time, but obviously there's some discussions about what's going on. I'll take another look at it in 30 days. Makes sense to you?
Yeah.
Right, and when you come with the return, to give you, let's see, what did we put this in, June? June 23rd. You can go to 24th. 24th, June 24th. At 9:30. All right, and that's when you come back for a review on this, and let's see if things have come closer together. Now, if you don't see me here, you see another judge, don't think that you're in the wrong place, okay?
Okay.
I'm leaving, so I probably won't see you again, but my notes will tell the judge where the case is, okay?
Okay.
All the best to you. This is case number 24166494, Oakland Community College versus Jayla Parrish. The matter is before the court, set on for a first hearing. The court is in receipt of the answer. The claim matter is for the sum of $3,729.86. Your appearance for Oakland Community.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Go ahead with your P number, Mr. Kuipers.
Oh, P 71348. My apologies.
All right, thank you, Counselor. Good morning to you. I'm looking now for Jayla Parrish. If you're on this Zoom, please say something at this time.
I'm here.
All right, good morning to you, Ms. Parrish. All right, so counsel, update where things are as an officer of the court, sir.
Your Honor, I spoke with the defendant. At this point, no resolution. We're just asking for 60 days of discovery and time for motions, and hopefully we can get it resolved during that time. And if not, we'll file a motion.
All right, Ms. Parrish, the attorney tells me that after parties have talked, you guys are not able to resolve this. I'm good, Mr. Parrish. Good morning to you. All right, Ms. Davis, as an officer of the court, updating on where things are.
Your Honor, this is our first hearing. I believe it's a status conference. I have not had a chance to speak with Ms. Westbury. She didn't want to meet in the breakout room this morning. However, I do expect if this case.
Yes, good morning, Judge. Francesca Servi for plaintiff P 87205.
All right, thank you, Counselor. Mr. Richmond, you still there? Good morning to you again, Mr. Richmond. All right, Counsel, so what's going on with this? I think the parties discussed it, did they not?
Yes, Judge, we did discuss. There's not been a resolution, so I think at this time, just a scheduling order, and we'll go from there.
All right, Mr. Richmond, that about the size of it, you talked about it, but you're not able to reach an agreement at this time, is that true?
Yeah, we weren't able to reach an agreement yet, or so will we be able to, like, what would be the next step? Like, will we be able to have another court date, or?
Yeah, the next step is for me to set up a scheduling order that will give you a new court date and will give the parties the right to exchange information under court order. And so that next date will bring you back on July the 24th. July the 24th, and that will be at 9:45 a.m. Now you'll get that date and time on the notice that I'm going to send out. That's July 24th at 9:45 a.m.
All right, thank you. Okay.
Get paperwork in the mail in the next few days. Which
All
both
right.
sides.
All right, thank you.
Okay, thank you, Judge.
All right, so I can leave now?
Yeah, you're all set to go, sir.
All right.
I may have given you the file already, but I had that issue. Come on, that's something. I'm not here. But I was going to issue a schedule.
Oh, okay.
On another one.
That's,
Send it up to you.
okay, I think that's at 494. Yeah. All right.
So, yeah. You said you just called. I wouldn't blame it on her, and
Do we still have a case in the breakout room?
yes, we do. All right.
Okay.
I'll send you good. I'm gonna send you a text too, just to update you again. Then the text you. The text will tell you. So I'm sending that to you now. All right, This is case number 23-151-688. This is Credit Acceptance Corporation, excuse me, versus William Johnson. The matter is before the court on a petition to show cause. Your appearance for credit acceptance.
Good morning, Judge. Francesca Servi for Plaintiff Credit Acceptance, P87205.
Thank you, counsel. Good morning to you. I'm looking now, looks like I'm looking for Michigan Provisioning Center LLC. Someone representing them. Your appearance.
Good morning, Your Honor. Sean Mansour on behalf of Michigan Provisioning Center, LLC.
Your P number, if you will, Mr. Mansour.
Yes, P78438.
Thank you, counsel. Good morning to you.
Good morning, Your Honor.
This is on the plaintiff's motion, an affidavit to show cause relative to a judgment that was entered against one William Johnson, and there remains a balance on that. And apparently, the respondent to this matter is a Garnishment defendant. Counsel, bring me up to date on this, if you will, from credit acceptance perspective.
Sure, Judge. On this one, there was a writ of garnishment that was served on Garnishee Michigan Provisioning Center back in November of 2024. Defendant William Johnson is employed there. However, Garnishee Michigan Provisioning Center has indicated that because William Johnson is a contract employee, they believe that they were not responsible for garnishing the wages. But per the court rules, MCR 3.101 A4, this would have been something that falls within a periodic garnishment as other payment made to defendant throughout the course of the writ. And so plaintiff has brought this motion to show cause for failure to withhold any of those garnishment funds from the time that the writ was served back in November of 2024 until present day. Now we would be seeking the costs and back pay from that garnishment.
Great. I'm sending you a notification. All right, I'll talk to you.
Thank you.
Thank you. I do see that the parties are back regarding the credit acceptance versus Johnson matter, more specifically regarding Michigan Provisioning Center. All right, and Madam Counsel, if you will update me where things are at this point.
Yes, Judge, we were able to come to a resolution by way of stipulated order. So the parties will stipulate that plaintiff will accept $1,720.22 from Garnishee Michigan Provisioning Center LLC, and that's to be paid on or before August 17th of 2025, at which point the judgment will be considered satisfied. However, if Garnishee Michigan Provisioning Center were to default on that and not meet the payment by that date, plaintiff could enforce the show cause and have back pay ordered from the date that the writ was served in November of 2024.
And that is correct, Your Honor.
All right, thank you. Thank you to both sides. I have noted the stipulation regarding $1,720.22. On before August 17th, 2025. And if that is all the case, it will satisfy the judgment regarding this matter or any claims against Michigan Provision. If that's not done, court then adjourns the show cause until a future date. So what's going to happen is, of course, if that matter is resolved the way that the parties have agreed that it would be, that would be the end of it. If it's not, then Ms. Priscilla certainly have to file a notice of non-compliance and the show call is set up. Makes sense to the parties?
Correct, Your Honor. Thank you.
Yes, Judge.
All right, good day to the two of you. I'm glad you took a moment to talk about it. I'm glad they would be worked out. And all the best to both.
You too, Judge.
Thank you, Judge. I have one more, so I'm going to stick around.
Yeah, I called it before. I thought I was.
Oh, okay.
Somebody informed me that you were the one that was on. So we're back on the record. The gentleman is here as well. We're back on the record regarding the suffix 8496 as credit acceptance versus Danielle Richard. Richmond. And this is looks like a first hearing regarding this matter. And go ahead with your appearance.
Okay, thanks.
All right, absolutely.
Okay.
The court calls case number 24-007. That's Jennifer Westbury versus Bill Properties LLC. The matter is before the court after filing a responsive plea. Today is the first hearing regarding this matter. Your appearance for any attorney who's appearing. Your appearance. You have an attorney.
No attorney, just Jennifer Westbury.
Attorney, if you're not an attorney, you should not be saying anything at this time. I'm looking at Bill's.
Good morning, Your Honor.
Is there an
Yes, good
attorney?
morning, Your Honor. Yes, Kristen Davis appearing on behalf of defendant Beal Properties. My P number is P77139.
All right, thank you. Thank you, Ms. Davis, and good morning to you. I'm looking now for Jennifer Westbury.
Yes, this is Jennifer Westbury. How you doing?
Reading oftentimes is something that is not 100% of one side, not 100% of the other side, but they find some common ground and they say, I'm willing to deal with it that way and move forward and be done. The next step is you know, if you have to do that, you have to do that. That just takes longer, it takes more and more. So I want to give you a moment to do that. I have no horse in the race, so to speak. I have no criticism. If you can't find a way, then I'm not mad at you, you know. If you do, then of course it works out really well. So here's the notification. I'll be waiting on the other side.
Okay, you can go to the breakout room if that's fine. That's okay.
All right, this is case number 24-168469. This is Credit Acceptance Corporation versus Danielle Richmond. That is before the court. Looks like I haven't set for a status conference. This is the first hearing regarding this matter. All right, your appearance for credit acceptance, please. Credit acceptance. Do I have Danielle Richmond? Mr. Richmond, if you're on the Zoom, please say something at this time.
Yes, I'm here. Hello.
All right, thank you, Mr. Richmond. I do see you there, sir. I believe that Mr. Rosen is the attorney for credit acceptance. I'm going to reach out and try to get him to come in the Zoom. He's in another courtroom. As I understand, we'll come back to your matter, sir.
Excuse me, this is she was on the reserve.
Just one moment.
She was on there, the attorney, she spoke with them in the breakout.
Okay, all right. Yeah, the attorney is in the breakout room, so when she comes back in, case, then we'll go forward with yours in just a moment, sir.
Okay, you said hello?
Yeah, just sit tight for a moment. I'm waiting for the attorney for acceptance to come out of the breakout room. Then I'll come back to your man.